All right, Judge, thanks for being here.
My pleasure.
All right, I know you've got to be at the courthouse at 10 o'clock to dispense some justice, but we appreciate you spending this first hour with us. I think the best place to start is really just at the beginning. I mean, you were born in Fort Campbell, Kentucky, and I know you grew up at least some of the time in South Georgia. And so I was wondering if you could talk a little bit about your early life, and in particular, if there were things about that stage of your life that you think made you who you are, maybe as a man, as a judge, as a lawyer, the influences from your early life.
Well, perhaps I should first say why I was born at Fort Campbell, Kentucky. My father was career military, so I grew up as an Army brat, and that continued until 1966, so I would have been about 11. We were stationed in Germany at the time, and we came back to my mother's hometown, which is Blackshear, Georgia, deep in southeast Georgia, because he was deployed to Vietnam. If you think about that time in history, 1966, you'll realize that we were going through the process in this country of school integration. That was totally unfamiliar to me because in the military, of course, schools and everything else had been integrated for many, many years. That was not the case in Blackshear, and for that matter, hardly anywhere in the South in 1966. And let me ask, show of hands, who has heard of the name Lemuel Penn? See one and a couple of hands. Googling later, you'll find some interesting things about him. I remember very vividly Colonel Penn. He was a reserve Army officer who was he was a teacher in Washington, D.C., and in 1964 he was driving back from Columbus. He had been doing his summer training. He and two other Army officers, all three African American. Went through Athens. At the time, Athens was going through a lot of troubles because the Ku Klux Klan was very active there. They followed their car outside of Athens and pulled up beside it with a shotgun, fired into the car, killed Colonel Penn, and wounded one of the other officers. They tried that case first in state court on murder charges, and the jury quickly acquitted the defendants. And at that time, the federal government was beginning to get involved in these civil rights violations because the states weren't really able to address them, as the verdict in that case indicated. And so there I was, 11 or 12 years old, and at that time the federal process was just getting cranked up. And all this happened here in the Middle District. I didn't know what the Middle District was at the time, but I knew it was Georgia, and it was Judge Boodle. That was one of his early significant civil rights cases. There's a Supreme Court case, United States versus Guest. I don't think it's studied in constitutional law. The principles are, I don't know, it should be here in Mercer anyway, just because of the local connection. But in any event, that watching that unfold, and I had an interest, of course, because of my father and my background as a military brat. I followed it closely. Remember Judge Boodle's role in that. Manly Brown was a law clerk for Judge Boodle at the time. Of course, that's not something I knew until many, many years later, and worked on that case. And so that got me interested in the law. I think, how do you really know exactly what's going on when you're 11 or 12 years old? But I feel like that's what really sparked an interest. And the fact of the matter is, from that time forward, I wanted to go to law school.
Well, and you eventually found your way here. And and you would have been in one of the early classes in this building. The law school had just moved over here. How'd you find your way to Mercer?
Well, after my father, he was killed in Vietnam, so we stayed in Blackshear. Again, it's a small town. It's a great town, and I certainly enjoyed going to high school there. I didn't have much contact with lawyers or really much contacts out. I had gone from the Army life to that life, and as much as I enjoyed living those years in Blackshear, I didn't really know much about how things were done. I went to Valdosta State College then. I enjoyed that a lot. Again, I always knew I wanted to go to law school, so I was a history major, which I may talk about that at some point, which is a good thing, I think. Back then, everybody wanted to go to law school. They made you a history major. And I started applying, got accepted several places, and, you know, probably, of course, Mercer had a great reputation even then, but probably it was more the local flavor than anything else that led me to come to Mercer.
Yeah, you're one of the few people that moved north to Macon.
Right.
We'll talk a little bit about your time in law school. These students have been here for one semester. They just started their second semester. They may or may not realize that they're forming memories. They're going to be with them and friends. They're going to be with them the rest of their lives. Talk a little bit about your time here and the experiences and the people and maybe even some of the faculty that made a difference to you, and be careful because some of them are still here.
There are some here. Well, maybe a way to get into that is to talk about what experiences, classes here meant the most to me. And the first one might be a surprise, both the course and the professor. It was civil procedure taught by Bruce Posnack.
Let's hear it for civil procedure.
Well, you know, I say that's a surprise, and I teach third year Georgia civil procedure still. I've taught that since 1999, and I talk about this with my students. I mean, I recognize in the abstract not much that is drier than civil procedure. I got intrigued by it, I guess you could say, because I love the idea that, okay, here are the building blocks, here are the rules you play by, here's how you figure out where you want to end up. And so it interested me. And Professor Posnack, great guy. Let's face it, he wasn't the most exhilarating speaker. So you put those two together, civil procedure and Professor Posnack did an excellent job with it, but again, he's a little dry. It's probably amazing that it intrigued me as much as it did, but it did. And what I have come to realize, and this is what I try and tell my third year students, I understand that looking at these rules in the abstract is hard to do, hard to grasp, certainly hard to get interested in. But trust me, when you get into practice, that stuff gets exciting, if for no other reason that it keeps you up at night if you don't know what the rules are. And also, I quickly learned that the more you know the rules, the more advantages you have, because the thing about the rules of civil procedure is that it's not just a right or wrong way. I think that's the way we think about it all too often. Okay, if I do it this way, it's wrong. If I do it that way, it's wrong. Usually, there's many ways to do it, and you're looking for the better way. And if you can use the rules to your advantage, to your client's advantage, to find the best way that gives your client the best advantage, over a lawyer on the other side who's just mechanically applying the rules, then you're much better off. And venue is probably the best example of that, but I will spare you my lecture on venue until I see some of you in your third year in my class.
Well, venue is a big deal in Georgia procedure.
It is.
I've told my students that. But, obviously you did very well in law school, and you had all sorts of options when you graduated, and the one you chose was to go with what was then called, I believe, Kilpatrick Cody, large Atlanta, commercial law firm. So you chose, having graduated from high school in Blackshear and gone to college in Valdosta, law school in Macon. You keep working your way north, and you find your way to Atlanta with the big law firm. Why'd you make that choice?
Money. Seriously, I came into law school thinking, probably like a lot of law students, certainly back then, that I wanted to do criminal law. I quickly found out that, while that was interesting, it was not what I wanted to do. I was fortunate enough to get a summer job at Kilpatrick, and then I had an opportunity to clerk for a federal judge, and this seems crazy, even crazier to me now, knowing what a great opportunity clerking for a federal judge is. I went on to Kilpatrick after I graduated. They had just bumped their starting salaries. The big Atlanta firms had from $24,000 to $30,000. I had a lot of debt, nothing compared to the debt that probably a lot of you have today, at least in just gross dollar terms. I had a lot of debt. I didn't have a car, so I needed the money. But I loved the firm. I loved being my summer there, and there was really, while money was certainly a factor, I joke a little bit because I saw it as a great opportunity, and it was a great opportunity.
Well, big firms take a lot of heat, you know, that they're unpleasant places to work, that it's a grind and so on. You liked it there. Tell us what you did and why you liked it.
Well, I was assigned to a general litigation team headed by 3 partners. And let me see if I can say this diplomatically. I understand, particularly after raising 2 boys, my wife primarily raising 2 boys, I understand the importance of a balanced life. I understand the importance of church, family, all those things. I probably didn't act like I did. But at the same time, there's not really anything easy about practicing law. There may be, and particularly when you get into a firm like that, you have to recognize that it's not a 9-to-5 job, and if you're looking for a 9-to-5 job, then you probably need to be looking somewhere else. So the reality is, in many legal positions, you're going to work hard, you're going to work long hours, you're going to be on call. So if that's not what you want to do, you probably need to look at something else. I was in that environment. Now, it was probably a little bit too harsh at times, and there was just beginning then, I think, a recognition that we need to allow our associates some time on their own. My wife still remembers me getting a phone call on Christmas Eve down in Blackshear, late Christmas Eve, from a partner I was working with. I don't know if they would do that anymore, but
yes, they would.
But it was a good. It was long, hard hours, but I worked with great people. Great in the sense that they were great mentors to me, not always pleasant mentors. You know, another misconception, mentor does not necessarily equate with nice and pleasant. There's part of mentorship that might be tough at times, and it certainly was tough at times, but it was a great experience for me.
You decided after 4 years,
Yes.
I think, that you would do something different. And you came back to Macon, to the Chambliss Higdon firm, of course still around and thriving. What led to that decision?
That's what my wife asked. Truly, I made that decision. It's crazy looking back on it now. She had an inkling I was thinking about it, but when I pulled the trigger on it, she didn't know. Now, she's from Macon, and she was working for a large hospital corporation based in Macon, but she traveled all over the country. So she was happy enough to be back in Macon, but she was very surprised that I had made that decision. Financially, it was a big change. I still liked Kilpatrick and Cody, but I felt that long term I was going to be better outside of Atlanta. I just didn't think I wanted to live in Atlanta. I'll have to say, looking back on that decision, if you just were to look objectively at it, it would be hard to justify, and probably harder to justify in today's world. It worked out fine, I feel like, for me. But
Well, so far, so good.
yeah. But I made that decision and haven't regretted it. And yes, came back with what was then Harris, Watkins, Davis, and Chambliss, a very good friend there, doing primarily insurance defense litigation, which was a little bit different than what I had been doing, but a lot of trial work at a time when lawyers were, and particularly young lawyers, were trying a lot more cases.
Well, while you were there, you got to know our old friend David Higdon. And I was wondering if you wouldn't mind talking about David, in particular a little bit, and about what he meant to you in your career.
Well, okay, we talk about mentors, probably an overused term in some ways, but, well, let me begin. Yeah, I alluded to this, when I came to law school, I didn't really know anything about practicing law. I didn't know lawyers. I thought that's what I wanted to do, but I just didn't know much about it. Felt like I had some good people helping me in law school, and very good people and mentors at Kilpatrick and Cody. But David, and I mentioned Manly Brown already, and I'll probably mention him again, but David and Manly stand out above anybody. And what David did for me, he took a particular interest in young lawyers, whoever they were. He then had a practice that was primarily workers' compensation defense. Statewide practice, very good reputation in that field, and he was branching out into workers' compensation claimants work. Unusual at the time, still unusual, for a defense lawyer in workers' compensation to transition or to dabble in claimants work. As he did that, it would spin off, his workers' comp cases on behalf of claimants would spin off, sometimes they'd have a civil claim, a tort claim, a plaintiff's case. I had done some plaintiff's work when I was with Kilpatrick and Cody, a little unusual for a big firm to do that, but another good experience. And so he and I started working together since I had that little bit of plaintiff's work, and he got me involved, and that started a very close relationship between us. And you know, David taught me so much, and I would say that the two things that I learned from him the most, he was very much a family man, as you know, very much a family man. He's deceased now, died way too young, and so he really helped me with that. And as I might have suggested, I struggled with that sometimes, not devoting enough time and resources to that aspect of things. And he introduced me to people, all lawyers around the state, his network of referral sources, and he just took me under his wing. My practice blossomed after that.
I forgot to distribute the roll, so
Okay.
I'll edit this out of the tape. Be sure you sign that before you go. Sorry about that. Well, while we're on this, let me ask you about Manly, because most of the students in here never heard that name. And in my experience, as we bring in guest after guest, they hear Manly's name almost every week. And so, tell us a little bit about Manly and his mentorship towards you. Manly still in practice here in Macon. Was he retiring? What, probably late 70s now?
Mm-hmm. Still very active. Well, let me begin this way, on a general note, about what I think of as mentoring. You know, I don't think mentoring starts off just as an older lawyer walking up to a younger lawyer saying, let's start a mentoring relationship. It's a two-way street, and by that I think this maybe doesn't get emphasized. You know, I think the way it gets starts is an older lawyer sees in a younger lawyer something that suggests to the older lawyer, this young man or this young woman wants to be a good lawyer. I can see it in them. I can see it in their work ethic. I want to help them. It's not just that they somehow this relationship grows out of thin air. I think it's sparked by the young lawyer. I really do, because if the older lawyer doesn't see that spark, that desire, that yearning, it doesn't. And I hope that makes sense, you know, for those of you out there. And I'm not suggesting that anybody fits this bill, but somebody like Manley, if they see a lawyer who really doesn't care, they do sloppy work, then they're not going to have any interest in investing their time in that. So, Manley and I, first, he is a legendary trial lawyer who was taught and mentored by a legendary trial lawyer, Hank O'Neill. He did clerk for Judge Boodle during the Civil Rights era, and then went into the U.S. Attorney's Office, where he tried hundreds of cases. He then became a nationally known plaintiff's lawyer, and that's how I got to know him. He and David were good friends, and we'd all work together on cases. And I guess I'm saying that Manley saw in me the things that I was just talking about, and he was more than happy to pull me in. He started sending me cases. We worked together, and he cares more than anybody I have ever known about ensuring that our profession, well, he has the interest in the individual. What he's, I think, really doing, he wants to ensure that our profession continues to be the type of profession that he thinks it should be. That is particularly the trial bar, a profession of ethical, professional, competent lawyers zealously representing clients in the appropriate way.
You may know this, other students don't, but about a year ago, I sat down in this kind of format with Manley Brown for 3 days, and we recorded his history, and that's going to be available very soon. So.
And I'm looking forward to that.
Well, the time came when you left the firm and went to what eventually became Adams, Jordan, and Treadwell. How did that come about?
It was a logical extension of the fact that I was doing more and more plaintiff's work, particularly medical malpractice work. I love Chambliss Higdon, still great friends there, but there's a tension, particularly in the medical malpractice field, where you're working on both sides. I had 2 good friends from law school, Jimmy Jordan, Virgil Adams, who were in practice together, and when I realized that I really needed to branch out, they were the logical choice. David and I talked about it. David was too committed to the firm, and he stayed, even though there was some tension with his practice as well there. Not among the lawyers, but just because of the nature of the practice. So Virgil, Jimmy, and I formed a firm, and it was 10 great years. It really was. And both in the relationships we had, financially, it was just a great, great experience.
Well, there's a lot of things a lawyer can do, and you chose, in that stage of your career, and of course earlier, to represent plaintiffs. What was it about that excited you?
Well, yeah, first I was excited representing defendants. I had, and I still sometimes continue to represent defendants, because Virgil was county attorney, and we did some defense work. It's never bothered me being on one side or the other, but I enjoyed the plaintiff's work more. Financially, if you do it right, it's more rewarding, to the extent that's an important factor, and of course it is. But what I really liked about the plaintiff's work is you were the master completely of what you did. You had a contingent fee arrangement. You could spend as much time as you wanted without worrying about a client complaining about the bill. You were your own master. You didn't have to take that case. If you didn't like the client, if you didn't like the case, you said, sorry, I can't help you. So every case you were working on is a case that you were working on because you wanted to work on that case and you could work on it the way you wanted to. So that, probably more than anything, is the reason I enjoyed the plaintiff's work as much as I did.
Well, the time came, 2010, I think it was, when the president nominated you and the Senate confirmed you to your current position. How did that come about, and what was it like to be vetted for confirmation?
First, how it came about, being a judge isn't anything that has been a career-long goal for me. I had not been politically active one way or the other, just because I was primarily then a plaintiff's lawyer. That would associate me more with Democrats than Republicans. Not 100%, but that's just the way that things were shaking out then. But still, I was not politically active at all. But about 2007, again, this was not a long-term thing, I realized that Judge Lawson was likely going to be taking senior status about the time the next president would be sworn in. And I looked at the election then, and clearly the Democrats had a good shot at winning, and I was more associated with Democrats. And as many federal judges say, the lightning just kind of struck, which is about the odds you have of being in the right place at the right time. That it all came together. It was a very grueling process first here at the local level. We did not have then, do not have now, Democratic senators. So the Democratic congressional delegation put together a committee. That committee did interviews. That committee, through the congressman, sent 3 names to the president. That started another grueling process. I came out on top in that process. That started the investigations, both by the White House counsel's office, the Attorney General's office, and then the FBI. That was interesting. I had to call up my college roommates and say, you're going to be getting a call from the FBI. Just to warn you. And didn't tell them any more than that, but just I didn't want them to be unprepared for that call from the FBI. Fortunately, when I was in college at law school in my early years, we did not have cell phones, meaning we did not have video of everything that we did. No Facebook page that could be dug up. And I'm joking a little bit, but don't get me started on my social media rant. Nothing wrong with social media. There's a lot wrong with how some young students use it. Hell, there's a lot wrong with the way a lot of old adults use it. But that's a topic for another day, I guess. But there wasn't anything particularly controversial about me. I had strong Republican support once it got to the point that I was selected. But you know, Washington is Washington, and there's always, particularly with judicial nominations, the party on the other side is trying to think of a way to slow the process down. Back then, what they were doing is requiring roll call votes for district court judges, which is very unusual. Usually that's done by a voice vote unless there's a controversial nominee. But they were requiring roll call votes for all. So I got a roll call vote. And the reason they do that is it takes a lot of time to do one roll call vote after another. So it took a while, but the vote was 89-0. So that was exciting. I didn't mention the Senate Judiciary testimony, which is notable only because Al Franken was presiding. So that was kind of fun. Once it got started, of course, you're real apprehensive about that, being grilled. I really wasn't grilled by a bunch of senators, but when you have Al Franken up there cracking jokes, that made things a little easier. So it was a fascinating process. I'm glad to have gone through it, and glad I won't go through it again.
Do I remember right that the FBI found a different Marc Treadwell? That seems like you told me that story where they found some.
You know, that's right. I hadn't thought about that in a long time. That they did for a while. I don't know if that led to much, but you know, so much goes on in that process. You know, there's rumors about, you know, something's going to derail the nomination. People think they know what's going on, and they're trying to tell you what's going on. It's a wild time, and I was still in private practice and trying to manage all that throughout that process was interesting.
I didn't tell you I was going to ask it quite this way, but obviously you know I was going to ask you about what it's like to be a federal judge. But let me ask you this way. When you first took office, was there anything that surprised you? Well, you've been in practice a long time by that point. Is there anything that surprised you from the judge's side?
Well, the thing that surprised me the most may not be particularly startling or interesting, but it continues to surprise me. I tried to keep up in practice with technology, even though this, you know, talking 2010. I mean, I switched our office from DOS to Windows. Most of you probably don't even know what I'm talking about. I was kind of a technology person, not that I'm a big IT guy, but I saw the potential for technology. So we were always trying to keep up using software available to lawyers, sanction, case map, things like that. I continue to push the law school to incorporate that into the curriculum. That's another subject. But so I kept up with it. I went in, and you probably don't know this, the legal profession started off using WordPerfect. You remember that.
Oh, yeah.
And by the 90s, because the business world was using Word, everybody had switched to, the legal profession had switched to Word. And again, you know, you tell the secretaries that they've got to throw away the WordPerfect and use the Word, throw away the DOS, use Windows. It's not much fun, but nobody likes change. What I'm getting to is this: when I walked in over there, it was such an isolated world. They had evolved from, on a technology standpoint, along a completely different path. Now we have great technological support. Our CMECF, our electronic docket, is fantastic. Every state should adopt it. But other than that, they were so ignorant of what the legal profession was doing. They were still using WordPerfect, for example, using no practice software, paper depositions, printing out stuff that the lawyers would send them instead of using whatever database that the lawyers were using to keep up with that stuff. And it was, you know, the judges did not know the technology. The law clerks had not been trained. They hadn't been exposed to that when they came in. And so it was in another world. I continue to tell my students, particularly those who are going into smaller firms, master the technology. You know, you get hired by a two-person firm and you're the one who knows how to use sanction. You're the one who knows how to use whatever. All of a sudden, you are a valuable part of that firm. So that was the most surprising thing. Maybe not the most interesting thing, but it surprised me to see that.
Well, students know just a little bit about what federal judges do because they've done federal subject matter jurisdiction, so they know diversity and federal question, that kind of stuff. Let's talk a little bit about your work as a federal judge. I think I know the answer to this question, but is there a typical day for you?
Well, Number one, and at this point it's probably not a surprise, we are not in the courtroom nearly as much as we used to be, and I hate that. And of course that trend began as a lawyer. But let me back up to the beginning and tell a quick story, because it just meant so much to me, and unfortunately it's an opportunity that I'm afraid you all will not have, those of you who want to be trial lawyers. It was right after I started at Kilpatrick and Cody. They were still doing some small defense work for Southern Bell. Normally we had big cases, but still we represented Southern Bell, and we were doing Southern Bell's liability work. And it was a little property damage claim with 3 defendants. Somebody had dug up a phone line to an insurance business that depended on its phones, and so they were suing for loss of revenue, property damage, that sort of thing. Georgia Power, a tree company that had dug up the power line, and Southern Bell. And the question was, who had screwed up the locate service and thus caused this phone line to be dug up? I went down just to answer a calendar call one time, which we hardly ever have calendar calls anymore, but it's where the judge would call the calendar call. The case was way down the list, so nobody thought it was going to be tried. But so they send me, the lawyer with 2 months experience, to go down there and announce the case and come back and say, all right, I got to go to court today. But we go down there, and as sometimes happens, calendar falls apart, and all of a sudden we're the #1 case. The judge sends us upstairs. We start striking a jury. I didn't have a clue what I was doing. First thing, but my client was the 3rd listed defendant, which meant I always went behind them, their lawyers. First thing they did, they sat down, took their legal pads, and drew a grid on it. One line across the middle that way, put it a long ways, and then they had, so they'd have 24 blocks on there. I didn't have a clue what they were doing, but I did the same thing. You might know what they were doing? That was our grid for striking the jury. That's how we used to do it. You just take your legal pad, draw your grid, and that's how you kept track of the jurors. The story got longer than I wanted it to, but the point was I got that trial experience. No cell phones. I couldn't go out in the hall and call the partner and say, I'm down here trying this case. I was just gone until the end of the day when I went back and said, I'm trying this case. And he said, well, it's your case now. But because of that experience, I got the opportunity to handle a lot of their small trials, and ended up trying, 10 or 15 cases or more while I was up there. All that is to say that it's a different world, and in many ways that's unfortunate. We're not trying as many cases. I would encourage you as young lawyers who want to go to be trial lawyers to take advantage of every opportunity you get, not just to be in the courtroom doing something, but now, for example, or as young lawyers, to be in the courtroom watching what good lawyers are doing. So we're not trying as many cases. The civil side of our practice is heavily motion dependent. Our civil cases are a wide variety, civil rights cases, of course, but diversity cases, of course, we can have any type of case. So there's usually a dispositive motion there. The law clerks get heavily involved in that. Our criminal cases generally plead out. We could have a discussion about the guidelines and what impact that has had on this question of jury trials, but they generally plead out. Taking a plea in federal court, for those of you who have to do that, go watch it done before you try and do it on your own. It's a colloquy, but it's one that has to be done right. Don't try and do it without having done it before. Then we get into guideline issues and the sentencing. We're still trying criminal cases, but we are in chambers a lot more than we're in the courtroom.
What's your favorite part of being a federal judge, and what's your least favorite?
The favorite part, I would have to say, is working with the law clerks. You know, they're all bright, right out of law school, eager, fresh. You know, they don't know. They know a lot, but they don't know a whole lot about what is going on in the real world. There's some time for development there where they understand or come to understand how I do things. I have to get them out of some law school habits.
Such as?
Well, mainly writing skill, or writing style. You know, judicial writing, good judicial writing, I'm not saying I do good judicial writing, has come to be very much to the point, address the issue, and move on. That's not what I always see in law school writing. We deal, and I see this in my third-year class, and I see this in the bar review programs that we do, and that is law students don't always focus on the narrow question being asked. And they end up talking about a lot of things that have nothing to do with the question that's on the table. I think primarily to just show, I know about this. I call it word vomit to my students. If you're talking about anything, it may show that you know a lot about venue, but I don't care. And if I'm a judge reading a brief, I don't care how smart you are on some topic that I'm not interested in. I want to know what you're saying about the topic that's on the table. And lawyers have a hard time with that too. So my soapbox, I talk about that a lot, as you can tell. Focus on the issue at hand and write about that. So we work on that. They come to see how I like to do things. And it's very much a collaborative process. I find that that's an adjustment they have to make. My law clerks they're clerking for me because they were good writers in law school. And sometimes it's an adjustment for them to get back a draft brief that I've marked all up in red and cut and added, and they're not used to that, but they get used to it. So yeah, working with the law clerks. You know, is the most pleasant thing. Most unpleasant thing, sentencing, not having done criminal work, is, I don't say it's unpleasant, and it's an evolving thing for me. I've come to believe that, and I've done this by talking to people who are coming out of prison, who have successfully navigated the path from prison back to the private world, the free world, and most don't. Re-entry is something that we have not learned how to do, and it's something as a society we need to learn how to do, not just for touchy-feely reasons, but it's in our interest in society to take these prisoners and allow them to re-enter and become productive for all kinds of good reasons, physical, compassionate, you name it. I mean, it's just, and which is why there's a lot of bipartisan support out there now for sentencing reform. But talking about sentencing, from talking to prisoners and former prisoners, what they tell me the most is that when they lose hope, that's the worst moment for them. So no matter how awful the crimes may be that I'm sentencing somebody for, I do not lecture them. Now they may do something that will require me to say something to them, but if they don't, I don't. You know, at that point, they don't need to be told they screwed up. They don't need to be told that they're a lowlife. They don't need to be told they're a drag on society. I'm there to give them their punishment and to not destroy whatever vestige of hope they may have left at that time.
And some judges do that. So.
I'm afraid they do. And what's the point of again, no matter how horrible the crime, what's the point, at that point, of telling somebody that they're just a lowlife? You know, what you want somebody to do, ideally, is to walk out of that situation and say, I've got to turn my life around. I don't want to put any impediment in that by anything that I say from the bench when I'm saying. Now, I'm not talking about coddling anybody, and I give them the sentence they deserve, but at the same time, I always wish them the best of luck, because they're about to go down a journey that won't be pleasant, and it's generally going to take one of two paths. They will be successfully rehabilitated or not. And again, I don't see why a judge should put any impediments in that path.
I've got lots of questions, but I want to leave a little time for the students here. The last question I ask all of our guests before I turn it over to students is this. You've sat where they sit. Do you have any advice for them as law students?
All kinds of advice. but really, I've thought about this a lot. And you know, older people are always talking about, well, when I was in law school. It's dawned on me now I am one of those older people.
Me too.
Yeah, you know, the class I taught, I began in 1999, I think I said, and yeah, when I started, I was one of them. Or so I thought, and it took me a while to realize I'm not one of them. I'm a generation ahead of these students, and that's the way they're looking. I may not be looking at them as a generation behind me, but they're looking at me as a generation ahead of them. So that took some adjustment, and now I know that when I talk on these issues, I can hear people a generation ahead of me talking about, well, when I was young, when I was in law school. So there's some of that here, but I've talked about writing, and that's important now because, quite frankly, I think that students enter law school with less writing experience and less reading experience than they had when I was in law school. Most of us then were liberal arts majors, meaning we had done a lot of reading and writing, history typically. Now it seems that there's many more business majors. Nothing wrong with being a business major, but I don't think it gives you the reading and writing background that some other majors do. And you know, we've changed as society. We don't read and write the same way as we once did. So, but yet law school and practicing law is these days mostly about reading and writing. So you've got to just, I think, acknowledge that, accept that, and work on those skills. This is an evolving thought in my mind, but lately what I've been focusing on is to do this, read the cases. Now, even when I was in school, we had ways to avoid reading the cases. But that largely defeats the point. The whole idea behind reading the case is to see how that judge or those judges reasoned their way through a problem. And so you can see how they reason their way and learn from that. I think writing skills are mostly the result of reading. I didn't learn how to write, I don't think, by sitting in an English class. I learned some things, but well, I feel like to the extent I can write well, and I have a fairly high opinion of my writing skills, it was from reading. And particularly in legal writing, reading the cases. Now some of them are dense and they're good examples of bad writing, but still you want to see how that judge, you're cheating yourself if you try and get the black letter rule out of a case and think you can come into class and you're prepared, but you know what that case holds. Even today, you know, if I'm really studying an issue, you know, I'm not looking for that head note. I want to get in there and see what happened and how they work through it. Now, here's the problem with that. I can do that today in about 1/10 of the time that it would take y'all to do it. That's just part of the process. Yeah, it might take me in law school 30 minutes or 45 minutes to really understand a case. But once you start doing it, and it's all about practice, once you start doing it, and then you see how that process works, there quickly, fairly quickly, becomes a time when you can do it in a few minutes yourself. But you got to learn, you got to start at the beginning. So if you're not reading the cases, if you're thinking, well, maybe I just won't get called on, or I've got the black letter rule, that's good enough, whatever it is y'all are using these days to avoid reading the cases, you know. Maybe it's the same things we use, but that's my thinking right now. The easiest way to get on track is to read those cases.
That's good advice. Let me turn it over to you all. What questions do you have for the judge? Don't be bashful. Yes, sir.
Judge Treadwell, I was wondering, you mentioned when prisoners lose hope, you know, and I kind of touched on something with me. What do you recommend we do with our clients when they're at that stage, when they're losing hope? How do you recommend we handle that moving forward?
Well, one, I didn't represent, didn't do any criminal work in practice, so I can't really say that I'm an expert. And I don't think as a criminal defense lawyer, you're not a social worker, you're not a counselor in any therapeutic sense. I mean, you're there, but you are there to provide your client with the best possible representation. So I think the way that you deal with that most effectively is to do just exactly that. Because I think the prisoners who lose hope, it's often because, yeah, it's often their lawyer's fault, but it's not because the lawyer wasn't a good counselor in a therapeutic, or they didn't hold their hand enough, or they weren't compassionate enough. It's because they didn't represent them. They didn't come see them. They didn't come see them prepared to address the issues. They didn't listen to what they had to say with regard to the facts of the representation. It was just going to be a case they were going to plead out no matter what. So I guess it's a little simplistic, but because it boils down to do your job. If your client knows, even if you don't have the best personality, even if you're not the warm and fuzzy and you don't make your client feel good, if the client knows, I mean, let's face it, these men and women, mostly men, are there because most likely they did something wrong. That's just a fact of life. Some are innocent, no doubt about it, but statistically, most likely they're there because they did something they shouldn't have done. They are not necessarily looking for a warm and fuzzy relationship, a reassuring relationship in that sense. They're looking for a lawyer who's going to do her job. And if you do that, that's the way best way a criminal defense lawyer can keep that hope alive.
I want you to remember that question. We're going to have a visit shortly in the next couple of weeks from Frank Hogue and Laura Hogue, the two leading criminal defense lawyers in this community. And if you remember, ask them. That would be interesting. What other questions? I'm interviewing them together. What other questions do you have for the judge? Yes, sir.
I think one of the interesting things thus far has been, it seems like each professor we have has a particular judge that they kind of identify with or admire, either past or present, and it's kind of different among each professor. Is there a particular judge, past or present, that you kind of have admired from afar and kind of respect their work or their writing style?
Well, you've heard me talk about Judge Boodle, and I don't know that I could really say much about judges' writing style. I've come to see some writing styles that I don't like in opinions.
You have life tenure. You can tell them good.
Yeah, I don't think opinions are there to have quotable quotes in the newspaper. I don't think that you begin with little cutesy stuff. You know, you're there, particularly a district court judge, we're there to get it out. You know, it should be something that's interesting to read, but you get to the point, you make your ruling, and you move on. I believe in good writing, don't get me wrong, but I don't believe that an opinion has to be a fascinating short story. Certainly doesn't have to be a novel. But in terms of, Judge Boodle certainly is somebody that I came to admire greatly. And then Judge Lawson, my predecessor, who still comes to work every day. He was a Superior Court judge for over 15 years before he was appointed to the federal court bench in 1995. And he is your quintessential judge. He looks like a judge, he acts like a judge, he's tough, he's fair. If you have a chance to be around Judge Lawson, I would highly recommend it.
I need to invite him to sit in that chair.
He would. He's responsible for Pat Longan being here.
Yeah, don't hold that against him.
And that's if you haven't talked about that story, that's a whole other fascinating story. But that was all Judge Lawson.
Yes, it was.
Who put that together.
I thank him every time I see him. What other question? Maybe you've got time for probably just one more. Yes, sir.
So you spoke a little bit about how the world is changing in the legal profession and how us as law students probably don't quite understand how the real world works. Is there something in particular, something very specific that you would say we should keep our eye on that's changing in the world that hasn't quite made its way through but would be there as we graduate?
You've got about 2 minutes.
All right. You know, when I said that law students don't really fully appreciate how the real world works, first what I meant by that was I'm of the firm opinion that law schools are professional schools and everything that is done in law school should be oriented towards preparing students to pass the bar and practice law. Everything else, there can be some other interesting things you do, but that's the purpose of law school. So that's what I was talking about there. I would encourage you to, apart from just the substantive law, to, as I alluded to earlier, learn as much as you can about the technology that's being used. By the way, I mean, if you can't keyboard, I was lucky enough to take typing in high school. And I took it because I was the only boy in that class. But by far, it's the best class I've had in terms of using every day. But firms today expect their young lawyers, I expect my clerks to be computer literate. And everybody is mostly, but also know the programs that are out there, know the software that is out there, keep up with the technology side of things. And push your professors to spend time on what they think you need to know in the real world to practice law. Good luck with that. That doesn't really, didn't come out quite the way I meant. But
Well, on that note, we're done. Thank you, Judge.